All right, welcome. I'm Dan Ho. I'm a professor at the law school here, also with affiliations with the Political Science Department and CEPR and with HAI. And we heard this morning from a really interesting discussion between Eric Schmidt and Marici Shaki about regulating big tech. And I think this panel builds on that discussion really nicely. The topic we're going to tackle in this breakout session is AI in government, and we're thinking of that really as having two constituent components. One is this panel is going to provide a little bit of a better descriptive understanding of how AI is being adopted in the public sector, and then try to get a little bit closer to the ground on potential pathways for governance in this space. And we have a just terrific panel here to tackle these two topics. The structure is going to be, first we'll have each of our four panelists start off with brief presentations, no more than 10 minutes, followed by sort of Q&A specific to those presentations, and we'll limit those also to 10 minutes. And then we'll open it up for a more general discussion between the panelists, and then open it up to the audience as well. It's very much meant to be conversational, hopefully inspired by the presentations at the tail end. And to make this simple, we're going to follow the alphabetical order of the program. And my role here is mainly to get out of the way. So let me give you brief introductions of the speakers who are going to be tackling this topic. Our first speaker will be David Engstrom, who is a professor of law at the law school here at Stanford. He's also Associate Dean for Strategic Initiatives and teaches a wide range of subjects from civil procedure, administrative law, and federal courts. He received his law degree from Stanford, his master's from Oxford, and a PhD in political science from Yale. The next panelist will be Sharon Bradford Franklin, who is the policy director for New America's Open Technology Institute. There, she's co-director of the Cybersecurity initiative and has a really wide range of experience. Most relevant here, she brings a wealth of knowledge on cybersecurity, freedom of expression, government surveillance, privacy, transparency, and platform accountability. And prior to joining OTI, Sharon served as executive director of the Privacy and Civil Liberties Oversight Board, an independent federal agency that reviews counterterrorism programs to ensure that they include appropriate safeguards for privacy and civil liberties. She received her law degree from the Yale Law School and clerked for Judge Jane Roth. Our third panelist is Peter Loewen, who is professor of political science at the University of Toronto. He's a fellow with the Public Policy Forum. We were pleased to have him last year as a fellow at CASBIS here on the Hill at Stanford. He directs the Policy Elections and Representation Lab at the University of Toronto and was formerly the director of the School of Public Policy and Governance at the University of Toronto. And he'll share, I think, with us some of his really interesting research on the role of technology in improving governance and representation and public opinion about sort of the regulation of AI tools. Peter received his PhD from the Université de Montréal. Our last panelist is Brittny-Jade Saunders, who is Deputy Commissioner for Strategic Initiatives at the New York City Commission on Human Rights. She is co-chair of New York's Automated Decision Systems Task Force, whose charge is to develop a process for understanding algorithms used by the city of New York, particularly when it comes to equity, fairness, and accountability. And she previously worked for the Office of the Mayor as acting counsel, where she was quite heavily involved in the city's broadband equity efforts. She has done a wide range of work pertaining to legislation about discrimination in credit and criminal history in the employment context, which was done by the Commission on Gender Equity. She previously worked for the Center for Popular Democracy on immigrant rights and racial justice, and holds a law degree from Harvard Law School. So with that out of the way, I think we'll have David Engstrom as the first presenter.
So I am going to spend my 10 minutes here reporting some preliminary results of a project that Dan and I have actually been co-leading here at Stanford, along with our colleague Tino Cuellar and also NYU's Kathy Sharkey. And the impetus for the project was our view that much of the debate over public sector use of AI has focused rightly on state and local use, especially within the criminal justice system. And so that means things like predictive policing and criminal risk assessment, about which there's been lots of debate. And the goal of our project was to look at a different, but we believe also quite important frontier, which is the use of AI by federal agencies for civil regulatory purposes. And so right now I'm just going to do a 10-minute overview of some of the findings of that project to try to prime our conversation here this afternoon. So I'll start out at a high level of abstraction, go all the way up to 20,000 feet, and present just a few results from what we call a canvas of the administrative state, and in particular the use of AI by federal agencies. And what we did is we assembled a team of 25 students, 15 law students and 10 computer science PhDs, and then we turned them loose on the federal administrative state. And we had them look across roughly 150 departments, agencies, and sub-agencies, and to try to surface as many AI use cases as they possibly could. And ultimately, they found roughly 170. This has allowed us to ask and answer three kinds of questions. So one type of question you might ask then is, so where is AI being used? And the answer is across the waterfront of government action. And this can give you a sense of that. So this is a breakdown of the different use types. Some of these are a little pedestrian, but important. So use of various MI tools to aid in the procurement process or to manage agency employees. Lots of regulatory monitoring and analysis. But many of the use cases in here are actually quite consequential. And you can see AI moving progressively closer to the coercive and redistributive heart of the federal government. So, for instance, lots of enforcement at some very important agencies like the IRS or the Centers for Medicare and Medicaid Services or the EPA or the SEC.
These percentages are of all the cases, not of 26% of all enforcement is.
That's right. It's of all the cases. Correct. Thank you, Margaret. So we're also seeing quite a bit, at least some, not quite a bit, but some use in the adjudicatory context. And that's really important because that means things like disability benefits and also patent licenses. So what's a second type of question we might want to ask? This is maybe for the engineers. What types of techniques are federal agencies using? And here's a sense of that. So take 171 use cases. So the 250 is sort of general claims of automation, but we identified 171 that actually used some type of machine learning. And we asked our engineers to actually identify further what particular techniques were being used. What we found is that the vast majority involve supervised learning of some kind, where the agency is trying to predict something such as facial recognition at the Customs and Border Protection, storm tracking by the National Oceanic and Atmospheric Administration, or chatbot responses at HUD. We also found small instances of unsupervised learning, such as the topic modeling of complaints received by the Consumer Financial Protection Bureau. So this is the agency that Elizabeth Warren helped to set up. Third type of question, where do these tools come from? And here's a sense of that. Surprisingly, most of them come from the in-house technical capacity of the agency. Some, in addition, come from, as you could imagine, the contractor procurement space. And then some come from competitions. That's what non-commercial collaboration is. So competitions, so these are competitions that are initiated by the agencies in which they provide essentially prizes and try to incentivize private sector provision of solutions. That's just a taste of our overview of AI use within the federal administrative state. Where do we go from here? Let's go all the way down to the ground level. And let me give you a couple of very specific use cases and give you some details on those, which I think will help prime our conversation. So start with enforcement. I already mentioned that several agencies, the IRS, CMS, EPA, are developing or using algorithmic tools to predict who is violating the laws and thus to focus agency enforcement resources. But I want to focus you in on the SEC a little bit, which is using multiple tools. So some of what the SEC is doing is quite predictable. They have a bunch of structured transaction data, and so they're using ML models to try to predict who's engaged in insider trading. But some of their tools are actually far more sophisticated. The SEC is also using natural language processing, NLP, to parse unstructured narrative disclosures to predict which investment brokers might be violating the federal securities laws. Now, these tools raise all sorts of interesting questions, some of them technical. They're interesting distributive and political questions, but we think that some of the most interesting implications of these new algorithmic enforcement tools involve the legal requirements of transparency and reason giving. And for the non-lawyers in the room, the puzzle is that despite the fact that enforcement sits at the heart of the coercive power of the state, the law generally insulates agency decisions to enforce or not enforce from judicial review. And the reason is that when agencies are searching for needles in haystacks and using these as part of their enforcement duties, we worry that their decisions aren't actually very intelligible, especially to generalist judges. And so we just hive off enforcement decision-making from judicial review. Interestingly, these new algorithmic enforcement tools can make that situation worse and better. Could make it worse because of the opacity of these algorithmic tools, which can actually make the agency's decision more inscrutable than before. But it's also possible that it makes it better. So these algorithmic tools, they actually encode the legal principles and also the agency's priorities. And so they could end up making enforcement decisions more intelligible, and they could cause us to rethink that presumption that we don't review agency enforcement decisions. Moreover, maybe these algorithms qualify as rules under what's called administrative law, and therefore would have to be subject to notice and comment review under administrative law. The result is that counterintuitively, algorithmic enforcement might, so long as we handle it correctly as a legal matter, might on net produce an enforcement apparatus that is more accountable in terms of who must face the coercive power of the state than at present. And so that might be a happy story, so long as the law handles it in a wise manner. What about a second case study? Let's turn to adjudication for a moment. There are a number of mass adjudicatory agencies within the federal administrative state, and they face a couple of very common challenges. One is inter-judge disparities in decision-making. So this is a graph that shows you that within the Social Security Administration, there are some administrative judges that grant disability benefits 5% of the time, and some that grant 95% of the time, which means that something other than the merits must be driving these decisions. Another common problem at these agencies are massive backlogs. This is the file room at the Board of Veterans' Appeals, where it can take sometimes 7 years for a veteran to get a decision. The Social Security Administration is developing some very innovative tools to try to deal with these problems. Some of these tools do triage. They try to cluster similar cases so that the administrative judges can move more equitably and efficiently through the body of case law. A second type of tool is called the Insight System, and it uses a machine learning tool to catch errors in draft decisions, as in this pop-up that tells the administrative judge to please evaluate her decision. And it leverages a manually developed decision tree, capturing 2,000 possible outcomes within a 5-step decision process, and therefore determines whether the adjudicators have used the proper pathing. And so it can actually identify 30 types of problems within draft decisions. So as with enforcement, there's some interesting technical and legal challenges here that we can leave for Q&A. But we think that one of the most interesting issues that this highlights is the challenge of government capacity building, and in particular the need for embedded, tailored expertise that marries law and technical capacity. And it just seems clear to us, having done a site visit with SSA and having understood, now that we understand better how this tool works, that SSA couldn't have possibly designed and implemented an effective, fair, and legally compliant version of this Insight tool without a detailed understanding of those 2,000 possible outcomes, of the regulatory backdrop, and of the organizational culture of the administrative judges who must actually use the tool. And so in our interactions with SSA, at least, it's clear that one of the biggest challenges facing government in this space with regard to public sector development of AI tools is the risk of a myopic focus on getting the next tool through the procurement process rather than maintaining, building internal capacity to innovate and to be able to critically evaluate those innovations. Okay. Let me close with one thought, which is we have tried to think hard about how we might build a sensible accountability structure around these kinds of tools. And we can talk during Q&A about what some of the regulatory mechanisms would look like. One of the really interesting questions is whether some of the very standard regulatory mechanisms might work quite well to build that accountability structure around what these agencies are doing. But we are also trying to develop some other possibilities. And so one idea that we have is that perhaps we could impose a requirement that these agencies engage in something we would call prospective benchmarking. And here's the idea. The idea is that agencies that want to adopt an algorithmic governance tool of some sort must reserve a random test sample and work up those cases in the old school analog fashion. So in the SEC context, the line-level prosecutors could be required to fully work up and investigate cases without the aid of risk scores, without the aid of these algorithmic tools. In the Social Security Administration context, perhaps the insight system could be deactivated for a random holdout set of cases. And the idea is it would provide a ready-made comparison across the analog and new AI worlds that could actually help us to get purchase on how these tools are performing. I'm already over my time, so I'll stop there, but hopefully I've primed the conversation at the federal level, at least along those three dimensions. So thank you.
So we have time for maybe 8 minutes of kind of discussion and questions specific to this presentation. I'm happy to start off if people are sort of gun shy. Maybe David, could you give the audience a little bit more of a sense of some of the kind of cultural differences that the research team observed in terms of the willingness, openness by different government agencies to actually adopt these tools. One of the kind of things that came out in the discussion from this morning, I think, between Susan and Eric, was the fact that 80% to 90% of the time is really about the front end of building the data infrastructure, hiring the right people, changing the organizational process, and I don't know to what extent, maybe you can speak to that a little bit as to the differences between the types of agencies that are actually willing to, like the SSA, actually develop these kinds of tools, as opposed to ones that are not.
Okay, great, sure. So I can actually stick with the two case studies that I presented. So the SEC and the SSA, I think that provides a nice contrast. The SEC is a very well-heeled agency. It's an agency that, as you know, regulates the financial services industry, and they have quite a bit of technical capacity, and there is quite a bit of entity-level interest in developing these sorts of tools. And so they describe for us meetings every week, every couple of weeks, in which all the different technologists within the agency gather and compare notes. And so there is a very strong innovation culture at the SEC. And the result is the SEC is way ahead of most other agencies in terms of developing these tools. And as I showed, some of those tools are quite sophisticated. The NLP tool that parses unstructured narrative disclosures is an impressive tool. So contrast that with the Social Security Administration, which is an agency that has to move enormous amounts of product, and you would think would benefit greatly from automation. It has the tools that it has largely because of the entrepreneurial efforts of a few employees, and in particular an appeals council judge. His picture was on the slide. That's Gerald Ray. And he had this idea that he could do this and that it could work. but he went about it in a very strategic way. He hired lawyers who also had tech sides to them, so lawyers who could code, and he brought them in and he put them on lawyerly duties, and he bided his time, and he waited until they had enough seniority within the agency that he could start to deploy them on more controversial on more controversial projects. And so Gerald Ray has been kind of the one-man show at SSA in making a lot of this happen. So that gives you a sense, and I think he's run into a fair few barriers along the way. We've met with one of his mentees, who is, Gerald is now retired, one of his mentees who's trying to drive this forward, and the sense is that there is some receptivity to it within the agency, but maybe not as much as you would guess, given that it is one of these mass adjudicatory agencies that's so thoroughly laboring under those two concerns that I put in front of you. This, on the one hand, the concern about interjudge disparities, which you would think an automated process could help to narrow a bit, and then also these terrible backlogs that mean that people who are in some pretty desperate circumstances in a lot of instances, so people who are needing disability benefits, are made to wait a very long time to get a determination as to whether they're eligible for those benefits. So.
Right. We've got 2 questions in the back, so why don't we take that left first?
Thank you very much. So you mentioned like how different federal agencies can implement AI, but I was just curious about these agencies also regulate each separate industries, and like they might have different approaches to regulating AI in sectors. My understanding is that National Highway Transportation Safety Agency are much more liberal and more promotive of innovation in AI in the automobile industry than the FDA isn't. So I was wondering if you encountered any of those sentiments while visiting these agencies, and then how would one eventually think about this? If there's different approaches to regulating AI in different sectors, like this federal agency, what's the overarching rule?
Right, okay, so I guess everything I just said about the SEC and the SSA and the different cultures, that is surely also present in terms of agencies that are thinking about regulating AI out in the world. We haven't had so much access to that, I have to say, because we have tried to keep this project cabined and focused on government use of AI. In part, that's because we're experts in administrative law. We love thinking about how bureaucracies do their work. And in part, it was just to keep it tractable. You can't sort of do everything. Where we've run into it a little bit is this idea of internal technical capacity. And we think that's so important, and I tried to hit on it a bit in my presentation. But you can imagine that building technical capacity can both fuel the development of usable, fair, accountable governance tools, but that technical capacity is also very important in terms of the agency's ability to, credibly to credibly regulate AI out in the world. And so NHTSA, for instance, is thinking hard about how it can build its technical capacity, because it knows with autonomous vehicles coming online at some point, we don't know exactly when they'll come on, in some sort of at scale, but that they know that at that point they're going to need to know quite a bit about the underlying technologies if they're going to be able to regulate them in an effective way. So maybe I'll leave it at that, and we'll move to a second question if that's okay.
Sharon.
Thanks, David. The quite striking thing was the 50%, rate at which these are being produced internally. I think linking that to your last point about benchmarking, I wonder if you can share with us the decisions that have been taken about use. Because one of the challenges inside a federal agency with this internal capacity that's generating it is, what is the evaluation about whether that use is appropriate, whether it's achieving the right objectives, is the quality, the quality that one needs, what outcomes are being optimized, what outcomes are being traded off. And so I wonder if you can share a bit from some of these examples. Like, you've got a set of folks, you've either got an innovation enthusiast at the top or an innovation enthusiast somewhere who's generating some new way of doing things. And the decision to actually use and institutionalize that, on what grounds is that decision being made?
So, I do think that, so I'm not sure, I'm trying to think of a good example where we've got real transparency over that kind of a decision. In general, what we found is outside the SEC context, a lot of the agencies are developing these tools in very bespoke ways, which is to say it takes a very particular entrepreneur to put forward a tool. And generally, not generally, but often this means an economist who learns some machine learning on the side, on his weekends or on her weekends, and then comes up with a tool. And so I wish we knew more about, once you have that tool, what kind of resistance or what kind of questions get asked as it moves up the chain. And I just don't have a great example for you there. I do think that this benchmarking idea, I think one of the reasons we're attracted to it is that we haven't found lots of rigorous validation and other types of testing of these tools. And I guess one reason why, although there are probably lots of reasons, is that there's like a basic catch-22 here, which is that the same budgetary shortfalls, the same hard budget constraints that lead agencies to need to develop these automation tools in the first place also prevent the kind of full testing that you would want. And so we think benchmarking is a great intervention for that reason, but it does impose a tax on innovation, because if you do have these agencies, that many of which are underfunded, especially in the current fiscal environment, you worry that they can get a tool just over the hump, just get it deployed, but they don't actually have the resources they need to do some kind of full validation or testing. And so if there is an external regulatory requirement, and there's lots of ways to structure this, but one way to do it is to make it a hard requirement. That does put a tax on the agency, and it means that we might have beneficial tools that don't come online at all as a result. So I don't know. That's just a couple of thoughts. I wish I had I wish we had a case study of that, of that adoption process that could give us some insight, as to what I take to be the more general thrust of your question.
Thank you, Jake.
Great. Thank you all. Thanks all.
Next up, we have.
So I'm going to talk about several uses of AI by government that pose certain risks. And I just want to start out by saying my point here is not that all uses of AI by government are bad. I don't want to go there at all. There certainly are some beneficial uses. But when you're talking about use by government as opposed to use in the commercial space, the government has the power to take away your liberty and to present you with or deny services that can be potentially life-saving or highly consequential to your life. So the stakes are a bit different in that context. And right now I'm not doing very well on my clicking. I'm used to a different kind of laptop. Bear with me.
Spacebar to get forward.
Okay, there I go. Thank you. I'm trying to use the mouse. Sorry, we're all different industries and different laptops. Okay, thank you. So I want to talk today about three illustrative categories of government use of AI that raise particular risks to individuals, and talk a little bit about each one. And those are the use in terms of public benefits determinations, use in pretrial risk assessments, and the use in various types of surveillance, particularly facial recognition technologies. And so starting with the case of the use of AI in public benefits. This is an area where you really can be denied benefits that are a matter of life and death or highly consequential to your health. And there was a book that came out in early 2018 by Virginia Eubanks, I don't know if some of you may be familiar with it, called Automating Inequality. And she did a study where she examined case studies in Indiana, in Pittsburgh, and in Los Angeles, where government agencies were relying on AI for a variety of entitlement type decisions. And for example, in her examination of Indiana, she looked at a system where they set up a system to automate decisions on entitlement to a variety of welfare benefits, and found that between 2006 and 2008, when they first launched the system, Indiana denied more than 1 million applications for food stamps, Medicaid, and cash benefits, which amounted to a 54% increase over the prior 3 years when they didn't have that system in place. And what she focuses on, and this doesn't mean, again, all AI is bad, but where you have a system that is relying on machine learning algorithms where people don't know what it is doing, and it is a very rigid system, it really compounds the harms to people who are poor, who don't have access to the same kinds of resources, both financial and access to making complaints to a government official that other people do. And it just compounds the problems that those individuals face. She found in particular that many errors were the result of inflexible rules, or any deviation from the rigid process that it had set up led to a determination that was called active refusal to cooperate, which automatically resulted in denial of benefits. And in part, she also found that the system was designed deliberately to remove the human element of relationships between a caseworker and somebody who would get benefits, because that was seen as an invitation to fraud, and the consequences of that, where it really was compounded the difficulty for people to get access to benefits or to challenge erroneous decisions. And relatedly, there is this problem with administrative law. I'm very intrigued by David's discussion of that in that context. In 2008, Danielle Citron, a law professor, had a work called Technological Due Process, which was fairly influential in this area, looking at how when agencies decide entitlement to benefits using machine learning, or what we often call black box algorithms, they cannot provide individual due process in the way we think of. We think of meaningful notice and a meaningful opportunity to be heard, and that they just cannot have these challenges. So I'm very intrigued by the suggestion of having your algorithm put out for notice and public comment rulemaking, which would really directly address that challenge. The other point she makes in her piece is when agencies delegate decision-making to algorithms, this in many ways undermines some of the rationales that we have for our administrative state, where we say courts are going to defer to the expertise of an agency in making the decisions if the agency, instead of having its relying on its in-house expertise, is deferring to an algorithm that they don't understand. It undermines that rationale. Some of the ways that people have pushed back against this have involved challenges through litigation. And one example that I have up here on the slide is in the state of Michigan in 2013. They initiated a system to detect fraud in unemployment claims, leading to almost 50,000 people being accused of fraud. There was a lawsuit filed in 2015. The evidence uncovered in the lawsuit ultimately showed that 90% of those determinations were inaccurate, but the state of Michigan, fortunately, was reversing those findings based on that lawsuit. So the second category I want to talk about is the use of AI in pretrial risk assessments. And this is a case where we really can have real risks of perpetuating bias in the system. The bias in our criminal justice system in the United States, sadly, is well documented, and algorithmic tools can only be as good as the data that they're based on, and so there is a tendency in this area to really perpetuate and exacerbate the biases that are found in our criminal justice system. Most notably, a sort of easy example is that we know that arrest records are biased against people of color because of over-policing in those communities, and so the training data can perpetuate that bias. There was a study in 2016, got some attention by researchers at ProPublica, showing these kinds of racial disparities in forecasting who would be repeat offenders and should therefore, at the pretrial risk assessment stage, be incarcerated. And compounding this here is an issue related to what I talked about in the public benefits context, where you have a lack of transparency that really restricts defendants' ability to challenge these assessments. In this context, in terms of pushing back, in July of 2018, a broad coalition of more than 100 civil rights, digital justice, and community-based organizations, including my own organization, the Open Technology Institute, released a shared statement of civil rights concerns regarding the use of pretrial risk assessment instruments. It highlighted some of these risks that I've been talking about perpetuating patterns of racial discrimination. And while criminal justice reform is not an issue that I work on that much directly, my organization joined it, some of the allies and people who are leading this charge really have been using this shared statement to engage in conversations with some of the jurisdictions that were employing these tools and having some success on that. The final category I want to highlight here is the risks of using AI for surveillance, and in particular focusing on facial recognition. Here too, we have a problem of detecting, perpetuating, and exacerbating problems with inaccuracy and bias. We heard Joy's presentation this morning very effectively. I don't need to say any more about what those issues are. But we also have, when you use these kinds of tools for surveillance, it really increases the power of the police to conduct pervasive and intrusive surveillance at scale in ways that historically police officers have not been doing. Our courts are starting, and the Supreme Court starting to recognize that this is not just a difference in quantity of surveillance, but can be a difference in kind, where it may raise to levels of violating reasonable expectation of privacy and triggering certain safeguards. But there's also the issue of what kind of tracking capabilities do police have with facial recognition technology. If your jurisdiction has a public video surveillance camera set up with all the footage, can the police use facial recognition to try and track an individual's movements throughout the city, or not in real time throughout their database of footage to track somebody and what standards should apply there? Raises risks there, both Fourth Amendment and also potential chilling of free expression. One study looking at this more globally, the Carnegie Endowment have put out the AI Global Surveillance Index findings. You see here on the slide, they found that at least 75 of 176 countries globally are actively using AI technologies for surveillance purposes, including smart cities technologies, facial recognition systems were 64 countries, and smart policing. They also had a finding that governments in autocratic and semi-autocratic countries are more prone to abuse AI surveillance than governments in liberal democracies. And finally, I know I'm running low on my time. I want to talk a little bit about some efforts to challenge the use of AI for surveillance. Joy referred in her presentation today to movements to call for a ban or moratorium on law enforcement use of facial recognition. My organization, Open Technology Institute, has joined in those calls for a moratorium. There was a coalition letter to Congress this past June from more than 60 groups urging Congress to enact a moratorium on any kind of federal law enforcement use of surveillance. There are also, as you heard referenced this morning, in various jurisdictions across the United States, including locally San Francisco, and then also in Cambridge, Massachusetts, they have now banned police use of facial recognition technologies. And there are movements to do that as well in other jurisdictions. And then just last week, just so that you don't think it's just the United States, I don't know that this is going to lead to a ban, but the Australian Parliament, interestingly, was considering a proposal for a national facial recognition database. And they said, hold on, wait a minute, we need to overhaul this proposal. This raises a lot of concerns about mass surveillance and the need for privacy safeguards. Let's take a closer look at this. And they called for that proposal to be revisited and redrawn for them. So again, I don't want to say that, I don't want you to take away from this that I don't think government should engage in any kind of use of AI, but in particularly where we're talking about programs that really can take away somebody's individual liberty or affect their access to benefits and that can be even life-saving, it really is critical to think very closely about what kind of safeguards would need to be in place and how those should be carried out. So now I take questions from here, right?
Hello. I'm Thomas Invers. My question is kind of more because I'm ignorant about U.S. law, but from the European experience, you need a law to allow these things. In my country, Estonia, we actually have an AI law that restricts this. Now, is there a legal basis that allows AI to perform these actions? Because I hear only of laws that restrict AI, but if the use of AI either by city, state, or federal governments, there's no law that...
So interestingly, so no, there isn't, but interestingly, these local laws that I alluded to, the San Francisco ban on facial recognition and the same one and also in Massachusetts, those are actually part of the San Francisco statute is part of a broader movement to require almost exactly that. So there's an initiative called Community Control Over Police Surveillance, or CCOPS, that is headed by the ACLU, and there's a model bill, you can find it online, and It is basically designed to put in place a statute at the local level that require communities to, and their governments, to approve any type of police, or in some cases it's broader, any kind of government agency, use of a surveillance technology. Because right now, in the US in particular, post 9/11, a lot of money became available for all sorts of technologies. And many communities, the police department would go out and say, okay, free money, I can get these great surveillance tools, stick them up, and the city councils didn't even necessarily know this was happening. And so this is really a movement to try and say, we need to make sure our community considers this, we have a public hearing, we expressly authorize it, put in place a law that says you cannot use any of these surveillance technology unless you get express permission from your local government. And the San Francisco ban on facial recognition is actually a part of a broader law that sets up that kind of system to put those kind of requirements in
It's
place.
still negative as opposed to a law that defines what can be done.
Oh, there's more components to it. It requires safeguards, it requires a data use policy and data retention. So I'm oversimplifying for time, but yes, there's more requirements in those.
Would you extend it to the private individuals who use Ring doorbell or self-driving cars collecting license plates?
So again, focusing on government use, my concerns with the Ring is more what the police have access to. So there's been a lot of reporting on how a lot of local police departments have signed up in the program with the Ring to get access to that footage. And there really aren't any kind of legal safeguards in place. And so we have a lot of concerns about whether that is being used as kind of an end run around Fourth Amendment requirements, because the police themselves aren't recording the footage, they're just getting access to it, and it's very unclear what kind of rules they're applying. But when law enforcement gets access to that, to those Ring doorbell cameras, yes, that raises very similar concerns.
So it sounds like you're saying no to these, not necessarily say, say if there were stronger validations like benchmarking or, some analog to that, and say a better understanding of the strengths and limitations, even thinking about the human services and say Medicaid entitlements, with those things in place, do you think is that the point at which we do consider these technologies, or do you just feel that, in the next 5 years they don't have?
So I would distinguish, this is very case specific. In the context of facial recognition, right now, we are not in a place, because of the concerns for perpetuating bias, the concerns for inaccuracy, and the extreme power of that technology. Right now, we're not in a place where we could say, okay, with this list, however long it would be, of safeguards in place, we'd be good to go. We're not there yet. With regard to some of the public benefits, I think there are safeguards. So a classic thing people talk about is having a human in the loop. David talked about having a human alongside the loop. If you're not actually making the final determination, but if you're using it as an alert system to fraud, this is a case that needs investigation, but then you have better means to challenge.
More like a prosthetic than an actual decision being made? More like additional context to inform a decision versus...
So that's going to raise far fewer risks, right. That would raise far fewer risks. So right. So in the context of facial recognition in law enforcement, that is a place where we are calling for an absolute moratorium right now. In other contexts, it really depends. It's very context specific.
So you have no ethical objections if the facial recognition software was 100% accurate? You wouldn't feel there are any ethical concerns about surveilling people 24 hours a day?
Oh, no, not at all. I hope I didn't convey that impression. No, that's one concern. The accuracy is one concern. No, there's a lot of concerns about bias. There's a lot of concerns about perpetual surveillance. For example, if you are going to use it for tracking, then we would say you would need a Fourth Amendment search warrant in order to track such an individual, and that's just one safeguard. No, there's a whole host of concerns, absolutely.
Any questions?
Okay.
I'll jump in there.
Sure.
So I guess there was an interesting exchange, I think, actually between John Etchemendy this morning and Marichi Shaki, really about kind of who, and I think this goes back to the earlier question about the burden of regulating and kind of the timing of it. And the exchange went something, for those of you who were not necessarily in the morning session, went something to the effect of well, there are some beneficial uses, even, and John mentioned in the facial recognition context, and so are we really matching, the right regulatory intervention here of a ban with what we know about the potential risks? And, how do we think about, in this space, the right timing of when to actually intervene? When do we know enough that we should call for, a blanket moratorium as opposed to, something that might be more tailored in terms of the prohibition for particular purposes? So I just wanted to open it.
Sure. I mean, again, I would say I think it is context specific. Law enforcement use of any of these technologies is going to raise a lot higher risks than a benefits determination, although benefits determination honestly can be a matter of life and death, so in some cases maybe that's at the same level. But I think when you're looking at a very serious downside risk, then we need to err on the side of delaying implementing these very powerful technologies. And so that's where the call for a moratorium on facial recognition in the law enforcement context comes in. I recognize that these are challenging questions, and I don't purport to have all the answers on exactly where you draw that line in each context.
Is anyone in government actually thinking about how to bring in the public's voices to, because it sounds like there's many different contexts. Each of those contexts has different people, stakeholders on both sides. One we should be particularly concerned about is the impact on society. Is there anyone thinking about helping to bring those voices into understanding these contexts, sort of rifling through them systematically?
So Brittany's going to talk about the New York task force. I'm not aware of any other task force like that elsewhere in the country, but that's one great effort that is going on. So maybe I'll just say that she's going to talk about that.
Thank you.
Thank you.
Well, it's a real pleasure to be here and to be back at Stanford. It's nice to see Margaret Levy here, who was the director at CASBS when I was there for this year, where I've done a lot of thinking about the things that I'll talk about today. So it's wonderful to see her and to see Thomas as well. Yeah, if you can get us a PDF, that's great. But okay, that's fine. It's fine. I'm not sure what altitude I'm going to present these findings to you at, whether they're at a very high level or a very granular level. You can decide. But what I want to do is make an argument about 4 obstacles to algorithmic government among citizens and among citizens' willingness to support the use of algorithms in government decision making. I don't want to begin begin the presentation, have you end the presentation with the assumption that I think that citizen consent is in fact the primary obstacle or the primary mover of government to using AI. In fact, I think most of it can happen without citizens being aware of it, but I think it's always useful to think about the case in which the circumstances under which something becomes under high public scrutiny, and then it becomes a basis on which widespread opposition or widespread support for government actions are employed. So what I want to do is present to you some data from multiple countries, mostly from my own country of Canada, on what things underwrite citizen support or citizens' opposition to government employing algorithms in government. And I'm looking very much forward to talking about it. I'll just put a couple of things on the table at the start. One is that there is a very good case for government employing the use of algorithms to systematically make decisions of various sorts. Obviously, the administrative state is becoming more complex, not less complex. That's happening on a lot of dimensions. It's making more decisions every day, but it's also, I think, finding it more difficult to make decisions as the capacity for government to act in a positive way is more constrained year over year. We rely on bureaucrats, that is to say humans, to make a massive number of decisions and to implement policies. Humans are highly imperfect people, overcome by any number of cognitive biases that will keep them from making decisions in a way that people designing policies or processes or indeed bureaucracies might expect them to make them. It's clear as well that more procedurally fair processes don't lead to better decisions. I was telling both David and Dan on the sideline that I'm always kind of really struck by these graphs that I'll see Dan put up in presentations about the complete lack of a correlation between a seemingly procedurally fair method for adjudicating some pretty constrained set of decisions, who should get VA benefits or who should get Social Security, and the absolutely massive degree of variance in the decisions that are made. You can set up a process with humans that's meant to be fair and to be even-handed and won't have any bearing on the actual quality of the decisions that gets made. And that's a very good case for automating some decisions. The state, it seems to me, is not designed to learn. That is to say that it's not clear that there are very well-designed mechanisms for one bureaucrat to learn from the decisions and then the outcome of those decisions that are made by another bureaucrat. So for all these problems, to some degree, there's a case for algorithmic decision-making to address these. Whether there's a sufficient basis of citizen support is a whole other matter. Here are some of the, just to put a few more priors on the table, these are, I think, some of the problems that are going to limit the use of algorithms. Obviously, there's, from a policymaker's perspective, and certainly from the perspective of politicians, there's a concern about supervision, about the capacity to actually understand what decisions are being made. Wrapped up in that is a whole series of principal agent problems, and explainability may even be a case of those. Then there's the issue of implementation, of actually wondering how, outside of the exception of very entrepreneurial, almost bespoke solutions that seem to be the norm right now, how it is the government see through the widespread implementation of algorithmic decision-making and algorithmic allocations in government. And then there's this final thorny problem of citizen consent, that underneath everything government's doing is a whole series of bargains that government has made with citizens about what's acceptable and what's not acceptable. And there's a whole bunch of assumptions that are built into that, which aren't written in law, but which I think guide the mutual understanding between citizens and politicians about how things will be. I'll use just one example of this. It's not written in law that our speeding enforcement mechanism on highways will be a system in which there'll be a low probability of capture and then a high fine upon capture, but we've all kind of agreed that that's the way it works. You can drive 20, 30 kilometers an hour over the speed limit, and you have some chance of getting caught with some fine. If you drive a lot more than that, you've got a chance. And the fine's a pretty big one if you're going fast enough, but most times you won't get caught. From a purely performance perspective, we're at a place where it would not be difficult for governments to be assigning speeding tickets to every person who speeds in every instance. And imagine moving to a model in which you've got almost perfect enforcement and very small fines. The amount of money that people could pay could be the same. It may have a different effect on behavior, but the nature of the bargain between citizens and law enforcement in that circumstance is very different. People are being surveyed all the time, their behavior is always being corrected. It seems to me that that's not written in law, that it's impossible to do that, but it is a case of citizens consenting to one system, and they may not consent to a different one that relied on technology at its core. So what I want to do is I want to just highlight what I think are 4 challenges to citizen consent for algorithmic government. One is that citizens support various justifications for the use of algorithms, but it's hard to find a full set of justifications that are strongly supported. I'll give you a little bit of evidence of that quickly. The second is that citizens evaluate, in the little experiments I'm going to present here, nearly any algorithmic innovation negatively versus the status quo. And I'll give you examples of some very reasonable, I think, algorithmic innovations, and you'll see opposition. Third, citizens don't develop trust in algorithms dependent on algorithmic performance. In fact, the standards they use to judge the performance of algorithms appear to be much different than the standards they use to judge humans. And finally, we've got fairly good evidence that to the degree to which citizens are opposing of algorithmic government, it's correlated with their larger fears about the effects of automation and AI in society and the effects that it's going to have in the future. And from the perspective of public opinion, I'll tell you why I think that's problematic. Okay, let's get through this stuff quickly. The data I'm presenting to you come from Canada, the US, and Australia. This slide comes from Canadian data collected this spring. We explained to people what algorithms were in a survey and told them there's a number of reasons government may use algorithms. Gave them all these reasons and asked them whether they support or oppose these being the reasons that the government might use algorithms. There's 2 stories you can take away from this. One is that, for the most part, the majority of people support any one of these reasons, if you take them on their own. And these are all pretty good reasons to employ algorithmic decision-making. But it's only something like a quarter of citizens who support all reasons, and 20% of citizens only support half the reasons. The bundle of reasons that you might give for why government should use algorithms, depending on that bundle, will have wide or narrow support. These are all very good justifications for using algorithms, but none of them are supported universally among all people. And I want you to think about what kind of challenge that creates for policymakers who are trying to justify why they're using algorithmic decision making. So that's barrier one. Barrier two is the following, is that status quo methods are preferred to algorithmic innovation. So without getting into too much of the details, let me tell you what we did. We presented people with an existing policy area which has some combination of an algorithm, it might just be a scoring system, and a human who's involved in it. We explained it to them. We did it with three areas: immigration decisions, tax audit decisions, and decisions about the allocation of small business loans by government. And all of these decisions, in the Canadian case, have a human as the final decision maker. And we, in each case, describe these things and then describe innovations that might be used to cut out the human at the end of the process. So I'll give you an example. With immigration, for example, we explained to people that the way immigration works in Canada is that people are they apply and they're scored, and this has always been the case for our economic selection of immigrants, or for a long time. Thanks, Dan. And then we said, there's other ways you could do this, as opposed to having a bureaucrat make the final decision. You could have a lottery among those who have a high enough score, which is in fact an algorithm, of course. You could just choose those who have the highest score, irrespective of any decision by a bureaucrat. And you could have some further interviewing and have an algorithm analyze those things. These are all effectively just proposed innovations. There's dozens we could have. The story is that every one of those is opposed less than not imposing an algorithmic improvement on the process. It's the same thing if we ask people about algorithmic innovations to small business. Every one of those innovations that we propose is supported less than the status quo. When we talk to them about tax auditing, again, it's the same thing. Every innovation is supported less than the status quo. You might see a pattern here about how people respond to the idea that a computer or an algorithm may take the place of a human decision maker at the end. The third thing is that reputation building is difficult in algorithms. So there's been a fair amount of work on this. We just did a little example in studies that we did in Canada, the US, and Australia. And the basic idea is we're telling people about a hospital in which the decision to assign surgeons to patients is made either by an administrator or an algorithm. It's hard to imagine a less sexy title you could give a human than an administrator, but I guess it gives people some maybe the faith in their competence. But what we did is we randomized people to get an administrator or an algorithm. And the basic story is that there's a surgeon operating on a person. This is a very obvious variant of a trolley problem. And that surgeon has a choice to either, there's a decision made about whether that surgeon will continue to operate on one person or operate on 5 who have just come in. And there's a utilitarian logic there and there's an ontological logic. And depending on your moral tastes, you'll support one or the other. But we randomize the decision that's made. The outcome is determined conditional upon that, and then we ask people whether they support the decision made by the administrator or the surgeon. The basic story, and if you're a sniper, you can read this at the back, but the basic story is that irrespective of the nature of the decision, when the decision is made by the algorithm, people are less supportive of the decision. They're in less agreement with it, irrespective of the decision made, right? So controlling for the content of the decision. It's the same thing in 3 countries. When we ask people then, would you support that algorithm or the administrator making the decision in the future? Again, irrespective of the nature of the decision, whether it was utilitarian or not, people are less trusting of the algorithm. And here's the most important takeaway finding, is that even conditional upon people agreeing with the algorithm, they're less likely to trust it in the future to make the decision that they would trust in. Which is to say that people aren't evaluating algorithms the way they evaluate humans, right? On actual performance and or on some inference about judgment. The final thing I'll just say is this, is that when we ask people about their apprehension about the effects of automation and AI on job security and on prosperity, when we ask them if they have a belief that automation and AI is going to lead to more social inequality, to less social mobility, those things are correlated with one another. And all 3 of those beliefs about job loss, about increased inequality, about hampered social mobility, are all correlated with a greater opposition to algorithmic government. That matters if you think that the types of political entrepreneurs who will marshal up support against algorithmic government may want to tie it in with other broader trends that people are uncertain about. So these are the top lines from the findings, and I'm happy to talk about them more. And thanks, Dan, very much for the invitation. Yeah.
Hi, that was great. Thank you for all that data. And I
I'd love to see the charts later.
Sure.
Not a sniper. But I do have a question in, thinking about other algorithms or models that have been used, like autopilot. I was just on a plane yesterday, something that's now totally accepted. Everyone has it.
Yeah.
If
you're not on a 737,
is it at a time factor that we expect that as this becomes more, it's kind of like the evil that I know is better than evil that I don't know. Is it something where you anticipate that over time, as some of these wins are more publicized and maybe communicated in a better way as we all learn these technologies how to communicate, do you expect, or have you seen other models where over time this kind of survey might change significantly?
Yeah, so that's a good question. So it seems to me there are a couple of things that are going on. I mean, one is, I think from the perspective of citizens, if you sit down and you talk to a normal person about algorithmic government, I mean, part of their question is simply going to be, can I get my license plate renewed online, right? Or can I get a health card online? I don't know if you have health cards in America, but can I get some government service online, right? And that's digital government, which is really a distinct thing. And I think that the appetite for that is getting higher and higher, and that service experience gets better and better, and people are more supportive of it. I'm just not sure that a generalized support for the use of algorithms is in government is possible. It's not something that people, I think, understand that you would have all departments trying to employ different forms of machine learning and artificial intelligence to make better decisions. What I can imagine is very strong pockets of opposition to different types of government employing of AI in ways that are uncorrelated to people's views and other things. So I'll give you an example. I mean, you can imagine people in a very high salience environment or high salience area like taxation or tax policy being just highly opposed to the government to basically fully automated auditing of taxes and then just assigning of tax bills by algorithm, which is entirely possible, irrespective of whatever views they may have on whether the government should be using algorithms to make small business loan allocations or to do college admissions or whatever. So in terms of, that's all a long way of saying that it seems to me the opposition to it can be very, very acute and very uneven. While everything is progressing, you can imagine there being very strong opposition to small numbers of things that are highly visible, right? And those could be the ones which really affect the bottom line of government or not, right? But I don't think that kind of a broad social consensus around algorithms is necessarily in the offing.
We have a number of questions from this side of the room. Let's start off with Margaret, and then several others.
So this follows right on what you just said, Peter. So I'm wondering how much this opposition, at least as you've measured it, matters. So how does it change into behavioral dissent or behavioral consent, or how does it formulate into opposition that actually has political salience? And you think about the case of the pilots and the, I mean, we didn't even, that just happened. We didn't get asked about it, and we can't do anything about it except not get on a plane. And I can imagine all kinds of government operations beginning to develop and then we either learn to live with them or there is a movement of some kind. But I'm not seeing how this particular kind of measured opposition translates into action.
Yeah, I mean, I'll give you a particular example in a particular area, but then a logic for why it matters more broadly. So in our own immigration system, the way it works is that most people are economic immigrants selected based on ability, and upon being accepted, you can then engage in family reunification, like you can here, where you're bringing in your family. Many more applicants for family reunification than there are spaces. So the way that the applications get analyzed is just by order in the queue. And order in the queue is determined by how much you're willing to pay an immigration consultant and how good the local consulate is in the town that your family is applying from. Government of Canada said, this is crazy, we should just have a lottery, which is the most fair way of dealing with this, right? If you've got a list of people who are qualified to come, who are longer than the spaces, you should just randomize over top of them. The opposition was enormous to this. It seemed unfair to people that this decision was being made effectively algorithmically rather than being made by a human who was deciding which ones, or by some kind of effortful thing that humans were doing. Completely upended family reunification policy and queues for a couple of years, right? So you can get it in high salience policy areas where people respond negatively. But I think the level at which it can impair, let's say, political courage by politicians is that depending on your system, is that they'll think about what types of things are likely to lay landmines for them. They'll watch colleagues go through these things and then not touch with a 10-foot pole the things that they think can make them go through the awful experiences that a colleague has gone through of having one acute area being highly scrutinized. Those areas are probably ones that have some combination of high exposure to citizens, so lots of citizens are interacting with them, high salience to those citizens, and a more or less okay functioning system that's making them work at that point in time that doesn't necessarily need a complete overhaul. But if you look at, I guess the final thing I would say is that the evidence for why, the evidence that we're not really able to adopt it is things like the VA. There's no good reason why so many decisions would be made so slowly and with such little effect if you could make them in an automated way, except that there must be some other kind of opposition to them. There may be other things there, but I think that the potential for highly salient political opposition that basically backlogs and slows down the progress of a whole administration or a whole department for years is a big matter.
We will still have time for general discussion, so let's batch the last two questions here.
I've never convinced Margaret with an answer on the first go, so.
No,
So I've got you two. Yeah. Okay. Let's batch them and then give Peter a chance to respond.
I wonder if you can speak a bit about what you think that this opposition really is. Are we talking about diffuse hostility against innovation or algorithms per se, an informed fear based on the number of reports that are, I think, popping up more now than in previous decades for obvious reasons, about the limits and the threats of algorithmic decision making, or perhaps an enduring trust in the sort of like types of decision making that humans can make along the lines that you guys talked about. What is this hostility? What is this opposition really about?
So mine was covered.
Okay. Yeah.
Great. No, that's a great question, Frederica. This is good. I wonder the degree to which people simply don't understand the scale of government, and are under the impression that government with people is the best form of government, which is to say you should always be able to talk to a person to help them with help you with your problems. I think that's actually at the core of a lot of it. So that doesn't necessarily suggest a hostility to technology, but it suggests an attachment to an older notion of how you ought to interact with your government.
Okay. I think we are going to save questions for the general discussion because we have Brittny's understanding.
Great. Thanks very much. Yeah. Thank you. Yeah.
All right. Good afternoon, everyone. Thanks so much for joining me, and Dan and David, thanks so much for having me today. So my name is Brittny Saunders. I work for the New York City Commission on Human Rights. My presentation is, I think, really designed to really bring us down to a very specific local government example, an example of a particular local government agency that is working to try to address some of these issues and grapple with precisely some of the same questions that my co-panelists have raised this afternoon. And I have a lot here just to kind of give you a little bit of context around what the City Commission on Human Rights is. I'm going to speed through it a little bit so that we can kind of dig into some of the questions that were raised, but the agency has a really interesting history. So it was founded in 1944 after an uprising in Harlem, which is a neighborhood in northern Manhattan, on the part of Black residents who were, concerned about conditions of overcrowding, of police violence, of housing discrimination, which were common experiences for Black people in the northern U.S. at the time. And so this first response on the part of New York City government was to create something called the Committee on Unity. It evolved over time into what is currently the City Commission on Human Rights. So we are a local government agency, just like I suppose the fire department or any other, except obviously with a very different mission. So our mission is really to enforce the city's very broad and very robust anti-discrimination protections. So we have a local human rights law that protects against discrimination in housing, in employment, and in public accommodations. We also have protections for something called bias-based profiling by law enforcement, which was put into place in 2013 in response to, a pattern of discriminatory policing, and then also something called discriminatory harassment, which is almost like a civil version of a hate crime. I'm not going to spend too much time on this. I mean, I think it might be of interest, but I won't actually read through each box, but it's just a little note on the commission structure. So we have a community relations bureau that is staffed by folks who do workshops and trainings with members of the public that are really designed to educate folks about their rights and their obligations under the city human rights law. We have a law enforcement bureau that's staffed by attorneys who will take in and investigate complaints from individuals who've experienced discrimination under the city human rights law. We have an office of mediation, and then an office of the chair, which is where I work, that does a lot of interagency partnerships and also promulgates rules and guidance and those sorts of things. Just to make the point about the expansiveness of our law, as I mentioned, the major areas of jurisdiction are employment, housing, and public accommodations. In many ways, the protections that we have kind of mirror what you will see in other state and federal anti-discrimination laws. So we have protections on the basis of age, race, disability, gender, which we define to include gender identity and expression, and many other different bases or categories. But we also have protections that you don't see in a lot of other statutes. So for example, in the employment space, we have protections on the basis of arrest or conviction history. We have protections in the housing space for individuals who might use a voucher or some other lawful source of income to pay for housing, and so on and so forth. I'm not going to spend too much time on this. It's just to say that our kind of relationship to interpreting our law as it relates to emerging technologies has kind of grown over time. In around 2015, folks on the commission, this is actually before I came to the commission myself, but started to notice that they were, seeing just through news reports and research more and more use of algorithms to aid in decision-making related to areas of our jurisdiction. So taking, for example, things like tenant selection tools that landlords or property managers might be using to help them identify who might be a good client, or the more common example of candidate selection tools that employers might be using to help them understand who they may want to invite back for an interview. And for us, of course, this raised questions about whether the folks who were designing and implementing these tools were doing this in a way that was mindful of the kind of extensive protections that the human rights law offers. And so one of the areas where I mentioned before, actually I think I just gave those two examples, so I'm going to speed through just for speed. So thinking about the employment example and tenant selection. So that's kind of how the commission started to engage around these issues, was through looking at kind of both largely, I think, private use of these technologies and trying to think about what is it that we can be doing to help folks understand not just that the human rights law exists, but how they might go about avoiding violations of the human rights law when designing and implementing these systems. At the same time, there was a lot of interest developing amongst advocates and subsequently within the city council around government use of what ultimately they came to call automated decision systems. I should note here that the term automated decision systems, or ADS, is really, really broadly defined in the local law in question, which is Local Law 49 of 2018. So it's really very broad, encompasses artificial intelligence, but also encompasses a range of other innovations that people might use that will be much less sophisticated. But the place where the council eventually landed was to create a task force, basically requiring the mayor to pull together a group of folks who would do some thinking around recommendations for how the city should approach the use of automated decision systems. And I am one of the co-chairs of that task force, along with the head of the Mayor's Office of Operations and the head of the Mayor's Office of Data Analytics. And we have been convening since spring of 2018. And I'll give you a little bit of insight now into how we have approached that work. So the mandate before the task force was pretty significant. And this is per the local law that I spoke about before. So, the task force is charged with developing recommendations around a procedure for how impacted individuals can request information on decisions involving automated decision systems. A procedure for determining whether a system is having a disproportionate impact on the basis of certain protected categories. Procedure for addressing instances of harm from systems that have a disproportionate impact or are determined to have a disproportionate impact. A feasibility analysis of archiving agency systems and associated data, a process for publicly disclosing information about agency systems, and criteria for identifying which systems should be subject to one or more of the above. So as you can see, any one of these things, right, is quite a complicated and challenging endeavor. And it was our task to, or it has been our task rather, to try to address a set of recommendations around all of these things. So how did we go about doing that? So the first step, of course, was to convene the task force. We pulled together a set of folks who have basically three kind of buckets of expertise. So we have folks who are experts on computer science and data science. We have folks who are advocates around a range of different issues and in support of a range of different communities, basically based on the recognition that the knowledge and the experience that those folks have developed advocating around those issues is going to be relevant here. And then we also have a number of folks who are actually staff at different city agencies, because I think, in my opinion, that's also a type of expertise that's really important when you're trying to develop recommendations for how to go about kind of governing these systems. So a little bit of insight into which agencies are on the task force. So we have the New York City Department of Transportation, Department of Education, Department of Social Services, the Mayor's Office of Criminal Justice, the New York City Police Department, and the Administration for Children's Services. And so what this reflects is both a diversity of agencies with different mandates. New York City has something like 50 different departments, but these represented, I think, some of the largest and most influential departments, and then also some of the areas, frankly, where there has been a lot of public debate or concern about the use of automated decision systems or algorithms or artificial intelligence, whatever the case may be. And yes, so that's the membership. And someone had asked a great question earlier about public engagement. And I'll say that I think as soon as legislation was passed, we recognized that there was going to be both a need and an opportunity to engage residents of New York beyond the folks who kind of think about these issues on a day-to-day basis because they are researchers or because they are government officials or because they are advocates in this space, to engage folks in the conversations about this. We went through this a couple different ways. So one was that we did 2 large public engagement sessions in the spring of this year, where we had folks with a range of different expertise come and basically offer insights and recommendations to the task force members. And we also had significant periods of time set aside for public engagement as well, so for questions from members of the public. In addition to that, we also did a set of community sessions where we went out and connected with young people or residents of different parts of the city to get their perspectives and their questions and their concerns around these questions as well. I am now running out of time, so I will just go to my last slide, which is just to say that we are going to produce a report with that set of recommendations in late November, so you should look out for that. But maybe I'll stop here and take questions, and then we can transition into the broader conversation.
I have a question. I know there were earlier issues with the committee not being given access to the kind of the data or the insights that they needed. Has that been, are there updates around that?
Sure. So for folks who didn't follow this or don't know, there were some task force members who felt that they needed to have basically access to current city systems in order to develop recommendations around how the city should think about these systems. We did end up having some city agencies come and present on systems. For example, we had the Department of Education and the Department of Transportation come and present to the task force in order to provide some additional insight. I think it was helpful. I think it helped to strengthen the process, so yeah.
Thank you for making me homesick for New York. When you make your recommendations, what do you hope will be the next step?
Yeah. I think that's a great question because I think it's a really important point that this is not the end of the conversation in New York or anywhere else, right? Like this is a initial kind of starting step, a set of recommendations that I think we anticipate folks will hopefully build on. It's hard for me to say, it's in large part because it's not up to me, what happens next, but you can imagine some of the pathways that usually, end up emerging. So it goes to the mayor, and then it goes to the city council as well. So they'll each consider what steps they want to take based on the recommendations. And then I'm guessing there will be a lively public dialogue around the report itself as well. And so I'm sure there'll be more to come out of that as well.
You said there were 2 large public sessions that involved the public, and then there were other community sessions. Over what time period was that, and how many-ish?
Sure. So that was between April and September. And then we did the 2 large sessions and about half a dozen other sessions across the city.
So it's a very small representative sample of the city of 8 million plus.
Yeah, you have to start somewhere, but it's true. And I think one of the things that we're certainly thinking about is how to engage a broader set of New Yorkers in these questions. I think it's not simple. One of the things that I have observed in this process is that for a lot of reasons, right, not the least of which being the kind of current federal context in which a lot of the communities that we would want to engage are under attack in a lot of ways. I think can make it challenging to try to get folks to necessarily invest really limited capacity under really difficult circumstances in this, but that doesn't mean that there isn't room for more kind of innovation and thinking and collaboration and going straight to people and all sorts of other things to kind of get over that hump. I think, did you have a hand?
Yeah, I was going to ask, have there been conversations at the local level around potentially updating the human rights laws that you're using to ground the commission's work to delineate more specifically around sort of some of these technological advancements, the way that it's happening sort of at the global level around if we start naming like every potential right or every potential violation of a right, then are we softening sort of the body of law? I'm wondering if that's happening at the local level.
That's an interesting question. I mean, I think we feel like the law as it's currently written certainly is pretty, powerful and could be used for a lot of different purposes. And in some ways, I like that flexibility because, the more you enumerate, the more you raise questions about the things that you're not enumerating. But yeah, I mean, there is some of that conversation happening.
I guess I'll jump in with a question. I guess it sounds like you've gone through quite the process here in terms of really thinking about the membership and community engagement. And I guess if you were called up by a sister jurisdiction that wanted advice, since this is kind of first of its kind about how to regulate in this space and how to create a kind of process like this for a municipality to really think about the right way to protect equity, fairness, and accountability principles. Yeah. Based on what you've gone through, what wisdom would you have to impart on your sister jurisdiction?
I mean, I think the first thing I would say is it's going to be hard. It's really challenging, especially from a government perspective, because you really have to. I think sometimes what people don't necessarily appreciate is that when you're working in government, particularly in local government, you're nested in all these different regimes that kind of govern how you work, right? So you have whatever federal laws might be applicable, state laws, local laws, and they're not always well aligned. There's not always a ton of effort to think about how different systems relate to each other, and you're operating under resource constraints. But all of that is to say that it will be challenging for all of those reasons. It's challenging because as government you have a special responsibility to kind of hold the values around equity and transparency and accountability. But those concerns are kind of distributed across the board. So there are obviously the very serious equity concerns that arise from the sorts of issues that Sharon talked about, right? So you have data that is kind of capturing decades of discrimination, and then you're using that data to train a system, and that has the potential to replicate all sorts of, replicate or amplify all sorts of disparities. But you also, as government, if you are in charge of getting people critically important services, right, you really do have a responsibility to think about how you can do that more effectively and more efficiently. And that in and of itself has equity implications depending on the services that you're talking about. So it's incredibly challenging. It's obviously maybe not entirely surprising, but it helps to set expectations. Two, I think it's really hard to overstate the role of trust in this. So like the communities that are impacted by these technologies and that we want to engage in these conversations also often are communities that have had really difficult relationships with government over time. And so, and then of course there's a current context issue. And then of course the examples of some of the most alarming examples, right, of how these technologies can be used in the wrong way. It all kind of compounds that that kind of lack of trust, and the need to kind of build through that and work through that is something that I think it's hard to overstate. And I think, I often think about myself as a really optimistic person. I'm sounding really down about it now, but I actually am optimistic about the potential to kind of thread the needle and get this right. But I do think, as challenging as it's been for us through this process, I think we did take the right tack by bringing together a group of people with kind of the three types of expertise that I spoke about earlier, because I think it is absolutely essential if you want to put together a set of recommendations that are actually going to be something that can be implemented.
I'm curious in terms of like more of the capacity to say look at health services.
Mm-hmm.
For example, like I could imagine that being difficult because there's so many private companies in the
Mm-hmm.
space, and they could be using their own, say, risk stratification tools, and say we have quality measures for facilities, but they don't necessarily break that down by, the individual characteristics.
Mm-hmm.
So wondering if you have anything going on in New York City around more population health management and measurement, and if you could maybe speak to some of the challenges in that particular area.
That is a really, really great question. I will say that I would not be surprised if the Department of Health itself were thinking about this, but I don't have a ton of insight into that, unfortunately. So I can't speak to it. Yeah, they're not on the task force, but that doesn't necessarily mean that they aren't doing a lot of great thinking around this. And actually, they tend to do a lot of great thinking, so I would look into it.
Okay. All to kind of react to do you see a particularly promising pathway for accountability, for instance, in this space?
I can start maybe and see where it leads, see if it generates some conversations. I guess one theme coming out of this panel so far has been just a basic problem of sort of multiplicity. So there's this the lure of a one-size-fits-all solution here, and they've even had a question, I guess, during my presentation that said, hey, like, what is the answer across the board here? And the reality is that there is going to be a ton of domain specificity in this area, and so I think that the logics of government use of AI at the federal level are going to be different from their use at the sub-federal level. They're going to be different across the civil and the criminal divide. Within particular policy silos, they're going to be different. And then I think Peter added to that notion of that sort of overall notion of multiplicity by pointing out that like the support and the justification for these tools is also like really quite spread across a bunch of different possibilities. And there's a basic cycling problem throughout. So I guess I wish that as a community thinking about these sorts of issues, we could work our way down into more domain-specific conversations more often. I do think that as we're kind of muddling through here and trying to come up with a solution, I do think that these conversations often get pitched at a level of abstraction that's not as helpful as it could be. And so just to close off then and say like take the two examples, the two ground level case studies that I presented during my presentation. Like those two areas vary tremendously in terms of the amount of transparency we could want over the tools. So in the enforcement context, transparency actually defeats the tool to some extent. Whereas in the the disability benefits context, like we probably want lots of transparency. In the enforcement context, maybe what we want is some kind of a system level accounting of how the tool works. Maybe we think that reaches or achieves a desired level of political and legal accountability. But when it comes to an individual benefits determination, maybe we want decision level accountings. We want an individual beneficiary to know what the provenance of the particular decision is. Maybe we even want open sourcing in the context of social welfare benefits. And again, the point is that the logics and the imperatives of all these different areas where AI is being deployed within the public sector are just going to vary. And so that's not very heartening, because it means that there isn't some sort of easy, across-the-board, one-size-fits-all solution. Rather, what is left for us to do is a lot of hard domain-specific work.
I think it's really well put. I mean, the thing I would add to it is that if you tried to back out from this kind of 2 or 3 rules of thumb that a policymaker or a top-level bureaucrat could use to evaluate whether some employment of an algorithm was good or not, in some broad sense, it's not even clear we could do that in some sense. I mean, around non-discrimination is very intuitive. That's an easy one for lawmakers to understand. It's a very good one as a rule of thumb. What's the rule of thumb after that, right? It's not transparency, because it's not going to work in every instance. It's probably not ease of explainability, because that's going to defeat half the purpose of using machine learning in some sense, right? To be able to understand the ingredients of things. So it seems to me that a real challenge is that for people who are trying to build out broad political support for things and bureaucratic support for things, not be able to give them a series of easy rules by which they would evaluate whether something is good or not makes the challenge all the more difficult. Not impossible, but it just makes it difficult for them to understand the scope and kind of evaluate the scope and the quality of the things that are being used in their department.
I agree that it's very context specific, and we can't have one size fits all. But with your thing about explainability and not wanting to defeat that, I want to push back against that a little bit. Or maybe you just mean in terms of who gets flagged for analysis and the trigger. Certainly the underlying, are you going to be accused of fraud, is something that we very much need to have people able to challenge and explain, and why did I get, why did this bad consequence happen? They need to be able to test that and adjudicate that and get beneath it, which is why I mentioned earlier, I was very intrigued by your up front, can we have notice and comment rulemaking on algorithms before we even implement them, to test that ahead of time? Because I think one issue that comes up in some of these contexts is the people who are making the rules or employing these are lawyers like me or other people who left math behind a long time ago. And there's a notion, I think, especially sometimes when judges are looking at these things, well, math must be right and I don't understand math, and a little bit of reluctance to test it, and of course the formulas must get it right. And sometimes that's going to be true and sometimes it's not, and we need to, at least in certain cases, be able to test these. You had your sample maybe that they could test and make sure it's running accurately, even if you can't dig underneath in every case. But having that kind of due process is not just important because it's a legal requirement in so many contexts, but just to give people the confidence and the faith of what is this magic math that's happening, is it really working properly?
Based on some of the agencies that you were looking at who were using machine learning technology, I mean, how do they define how they get value out of it? I mean, I think that's something that companies are struggling with right now. Like, most AI projects are stalling. So I would just be even curious, like, what does the SEC, if they're even having conversations with other agencies, like, look, we deployed this and we're getting X, 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 X. I mean, how are they defining value?
It's a great question, and it's not. I don't have a definitive answer as to any particular agency. We've had a lot of conversations with a lot of different administrators who've done this. So I think in a time of really deep fiscal constraints, I think the real value that my guess is what's driving a lot of the innovation that we're seeing within government is an ability to do more with less, and so it's the efficiency rationale. Now, maybe in some of the adjudicatory agencies, so maybe at the Social Security Administration, if we had them here and we could ask them, and maybe Dan could speak to this as well, because he's interacted with a lot of them, a lot of these these folks within, say, the SSA, developing these the adjudicatory tools. Maybe they would say that decision quality actually is what's driving us. So it's less about backlogs, it's more about narrowing some of those interjudge disparities that I talked about. But I have to think that in the enforcement agencies, like at the SEC, I think the principal allure, I don't know if this is right or not, but that the principal allure of these tools is that you can do more with less, because these are budget-strapped agencies and they have big regulatory mandates. They have more stuff than they can possibly do with the resources that they have, and they want to try to maximize what they're up to.
Yeah, for a number of federal agencies, there are these performance measures that are set up under the Government Performance and Results Act. And so for an agency like the Social Security Administration, they have performance metrics like the number of cases you've decided, the number of times your cases have been reversed. And so you're really grounding yourself by achieving those performance metrics, and sometimes that's good when you're directly able to measure what we care about in terms of promoting social welfare, and other times, if you're solely sort of maximizing your caseload, that can drive exactly the kind of dispersion that sort of irked Peter in his response. And so in these particular use cases, it was about being able to flag errors internally earlier through an automated decision system. Then, through what is probably not a very sophisticated evaluation, they claimed that, hey, through this tool, we were both able to improve consistency, lower errors, and speed up case processing times. But one of the kind of worries is that if you don't have something like a transparent evaluation method, it's really hard to know how much credibility to put into those kinds of internally generated reports. And that's part of the kind of political dynamic too in terms of the adoption of these kinds of use cases, which is for a lot of government agencies, it's really high risk to use a number of internal staff resources to develop something that you can't say was a winner all around. And I think that really affects where you end up investing. At an agency like the Securities and Exchange Commission, one of the interesting things to observe was that they actually did have more of the kind of culture of saying, we're going to seed 6 experiments, we're going to expect more of them to fail, but that's the way, that's like the right level of risk for us to actually make sure that we're building out in the right areas.
And just a quick rider to what Dan just said, which is, the political incentives that agencies are facing are very different across agencies, across policy silos, and what have you. Some agencies are claiming they're using machine learning, but when you put Stanford engineers on the case, they're not. And so in some cases, there are incentives for puffery. We're on the cutting edge. We're at the frontier of technological development of governance tools. But at other agencies, they are using it, but man, they want to stay off the political radar as much as they possibly can. And so it's been really interesting as we've fanned out across the entire federal administrative state to see some of those differences. And it hasn't always arisen in places you would expect. You might expect, for those of you who know a little something about administrative law, you might expect that the executive agencies would be most politically sensitive. Those are the ones who are under the direct control of the president, whereas the independent agencies, the independent commissions might be less so. But I don't think we've seen any regularity there in that regard in terms of the political sensitivities.
Yeah, the Stanford engineers, out of the 170 or so use cases, rated the degree of sophistication of federal use cases. And I believe that about 8% of them were rated high in sophistication. So it gives you a little bit of a sense of the capacity gap between the private sector and the public sector.
Can you release those? I would love to see the breakdown, like what is the most sophisticated agency versus the least.
Yeah, those will be part of a large appendix in a report. Yeah, we have more questions over here.
So I'm hearing several different issues being debated. One is sort of at the level of what Chapki was talking about earlier about what principles to use as opposed to the domain specificity or the technological specificity, and Peter began to have a response to that, but I'd love to see that explored a little more because I can think of other principles than discrimination or non-discrimination or transparency. But the thing that I'm also struck by is that another underlying theme that I hear from most of you has to do with creating confidence in these tools, both within the agency, within the public, and among the political decision makers. And so I'm wondering why there isn't, I mean, I probably can answer this question as I ask it, but it seems to me that this is a kind of area where a different kind of strategy might be tried. And I'm thinking here of the example of Code for America, or even some of the behavioral insight units, where you start with a problem which people really are being inconvenienced by, or they're being denied benefits, and you solve the problem with an algorithm and give people, or some algorithmic part of the solution, and you give people and the public and the decision makers some confidence that this can work in those kinds of contexts and settings, and then you can build up from that. So I'm not hearing strategies, really. I'm hearing like, this happens here and this happens there. Are there governments where there are, or groups, I mean, other than things like Code for America, where these kinds of strategic efforts are going on?
Yeah, I mean, I'll take the first crack at that. I think what the work that Code for America is doing is fabulous. I think one of the real challenges when you're talking about federal regulatory agencies is that you have to serve the public at large. And so the principal output by Code for America is usually an app. And that raises all sorts of questions about the kind of digital divide across different subpopulations. So I think that there has been at least some caution about adopting something that, you know, really may have disparate impact in some ways if it's only people with smartphones who can kind of access a more expedited mechanism of actually getting benefits. Brittany, I'd actually love to hear you. I don't want to. I'm a lot more than I don't want to cold call you. But the thing that I think Margaret's first question was so interesting, right? Because we had this. Marichi Shaki saying we have 128 frameworks for ethics in AI in Europe alone. And how do we take that broad set of principles and reduce it down to something that's more tractable than an open-ended call for, you know, equity and fairness? And that's so much of the work of this commission that you're up to. And I'm just curious, I know you haven't released the report yet, but it must be a struggle that you're facing in terms of not having the lowest common denominator, consensus position being adopted, and how do you move this really forward in a kind of material way?
So you're right. So we have developed a set of recommendations that we're going to be kind of applied to New York City government across the board, right? Mm-hmm. So that's one of the challenges. I think to your point about like how we tried to make sense of what's kind of already out there, like as I mentioned, we had these public engagement sessions. Folks came and shared their insights, submitted written materials. Some folks just submitted written materials. We kind of pulled that all together and have been using that to inform where we land. I definitely can't tell you where we're going to land yet. It's
on the edge of the seat.
Yes, exactly. It'll be coming soon. But I think the answer is really, probably unsurprisingly, iteration. So, this will be where we land in this phase. And then I'm hoping that we'll be able to, we ourselves, the City of New York, will be able to build upon what the set of recommendations is, and other folks will take it and, do with it what they will, and maybe they'll arrive at some of that kind of domain specificity and all sorts of other questions through that process as well.
And do the rest of the panelists have a response to Margaret's second question of, do we just need a different strategy here? Something along the lines of Code for America or Digital Brigade or the U.S. Digital Service, 18F, right? Different ways of actually fostering this kind of innovation from within government.
I would say three things very, very quickly. One is that I think public administrative structure matters, and understanding what the incentives are within different forms of government is going to matter quite a lot, actually. That's the first point. The second one is that there's, if we think about dimensions in which we want to classify things, there's all sorts of ones where citizens have no interaction with government, and that might be the place to really break out solutions as aggressively as possible. That works against the strategy of building citizen confidence, because citizens aren't interested in the control or function at the background of government or something, but those are good places to test, because there's a lot of stuff the government does over and over and over again. But the third point, which goes to a little bit to the speeding example that I gave, and certainly goes to tax audits, is that we shouldn't think that citizens want government to work perfectly. Citizens are actually pretty happy that there's a lot of stuff government doesn't do well, right? Like I think a lot of people when they file their taxes are pretty glad government doesn't do it perfectly on the audit function. They're certainly glad the government doesn't catch, some way fare cheats perfectly or speeders perfectly. So there's a degree to which I think we've got to be very thinking about the strategy of it, be pretty shrewd about the areas where citizens want improvement in a domain and to choose those ones, and not to just
efficiency.
That's right. To not presume that efficiency is actually one of the principal objective functions that citizens are trying to maximize on in every instance. People don't want there to be perfect enforcement of a lot of things.
I was just going to pick up on the notion of how you make the decision making. The earlier question here about getting the public involved and how, at least in your task force, although I haven't heard of any other jurisdictions stepping up to try and do something like that to bring in the public. But I did recall, I checked my former agency, it was mentioned, I had worked with the Privacy and Civil Liberties Oversight Board, which tiny agency reviews federal counterterrorism programs to make sure that they have privacy and civil liberties safeguards built in. One of the projects they are doing actually is looking at the use of facial recognition and other biometrics with regard to like not beyond the no-fly list, but that in that context. It's not exactly a public. It's not the same level of bringing in the public, but there is an opportunity to hear from the public, and so that is one context in which there is that review. But I wonder to what extent, think of your question and your New York model, there can be these, because I think getting the public's input is so important, whether it's the public rulemaking or thinking that through and how government can do that, because also I think with the challenges from my time in government, of government procurement and what you're doing when you're trying to think about building an algorithm in this new space, I'm sure that is part of the problem that's going on as well.
So, can I say one quick thing? It's a great question, Margaret, about strategy. And you immediately went to what NGOs or what civil society could do to sort of help shepherd this process forward in responsible ways.
Yeah.
But there's also a certain amount of strategic action at the agency level, and that's been interesting to watch as well within our project as we've tried to push it forward. So the SEC, I think, has been quite strategic, and that's precisely because they do some entity level. They have some entity level infrastructure for doing this. So I think they've been quite reflective about which tools they develop and when, and so they're kind of gradually sort of selling their regulated community on the use of these tools. Social Security Administration, which doesn't have quite as much, as far as we can tell, kind of entity level infrastructure, has also been quite strategic. If you think about which tools they've actually implemented, they're like well chosen. So the Insight system is an error correction system for drafts of opinions, and that's not likely to get anyone's back up, I think. A tool that I didn't tell you about is a tool that it's a machine learning tool that identifies easy grants. That is to say, cases that the agency is surely going to grant eventually, and the idea is to identify them early and then push them to staff level decision makers, and that then frees up time for the administrative judges to focus on the harder cases. That's also a great strategic move. If you're going to start to develop a machine learning tool, it seems like a win for everyone. It's also very hard to challenge legally. It's unclear how you would bring, who first of all would bring a challenge to that.
That's where efficiency would be.
It's possible someone who doesn't get the benefit of the easy grant process could challenge. It's not entirely clear they can get legal standing. We'd have to think about it a lot as lawyers to understand that. And so, the result is that the agencies are moving strategically in ways.
So could I encourage you two with Tino et al. To write up the strategic part of it in a
sure.
separate paper? I think that's really important for agencies to understand that there are strategies here.
But what you worry about then is, are they really strategic? Which means, our government tech overlords are figuring out ways to sell us on these tools as they work up momentum towards more tools that are much more, consequential and that maybe aren't quite as well designed and that actually, create problems. I don't know. This is why I think we're so wedded to this idea of internal technical capacity. There's this long tradition of administrative law that says that actually sort of internal administration is where a lot of the due process happens. it's not imposed from outside by courts. There's just too much going on within any administrative system for courts to really police it in any kind of thoroughgoing or rigorous way. And so what you have to depend on is reflective practice by the administrators who, who wield this really important set of public powers. And so the hope is then that not only they're thinking kind of instrumentally strategically about how to bring these things to kind of public market to use by government, but that they're also thinking about the moral dimensions of what they're doing and are asking often enough the question that Jeremy Weinstein asked, but he's now gone, about whether there's conversations within these agencies about whether these are appropriate uses in the first place.
Okay, question in the back?
Are there any tools which will kind of benchmark or quantify when an AI tool can be introduced in the human ecosystem? The ratio of human versus AI interaction, is there a way to quantify it? For example, you use technology radars, it's a map which tells when a technology is obsolete or when a technology is completely invisible, it's become a part of us, like the microwave or electricity, we don't realize it's there. Is there any benchmark like that which tells when it is the right time, the right ratio of AI versus human? Like a tool, do you have are you thinking about it?
Are you offering to build it for us? I don't think, I'm not aware of such a tool, but I think this ties in really nicely, I think, to kind of Margaret's question about strategy, because we do know that there are a whole bunch of preconditions that have to be there in order to even contemplate this, and then only then do you get to the question of like the right mix of how much to automate and how much to leave to human discretion. So it's agencies that actually have laid the backbone infrastructure to actually capture a bunch of data. So that's the example of Gerald Ray of getting to the agency at a point of time where everybody's just using WordPerfect or Microsoft Word to write down decisions. They're not capturing any structured information coming out of any of these decisions. And he starts to actually build out that data infrastructure to even get to this point of having a decision tree for how you decide a Social Security disability case. You have to have some folks on staff, and I think that part of what explains the 50% of the agencies who've really done, there's not really much public evidence of any experimentation, is there is a pretty substantial gap in terms of who sort of agencies are able to hire. And so there are attempts now, and this goes back to kind of the question of how to think about this strategically, where we've now had questions about moving people over to an exempted service or adding the parenthetical data scientist to a bunch of existing job classifications to make the hiring of those people easier, right? So there are a whole bunch of these preconditions that I think have to be there for an agency even to get to the point. Now, if depending on which agency you're in, maybe Sharon would think that's a good thing that those preconditions aren't there for some of them, but I don't know if others have.
I might just make this observation that when you see these estimates about what percentage of jobs can be automated, one way that these get backed out is that, for example, and I've done this in surveys where you ask people across 18 or 20 competencies, do you do the following things, right? And then we know at what levels technologies are performing at current levels of demonstration. But for example, if you take the McKinsey filter, which has got 18 questions, not a single one of those questions is, do you make moral judgments in your job, right? They ask questions about reading and navigation and inference and giving instruction, but there's no questions about moral judgment, right? Which seems to me to be one of the key ones about whether or not things can be automated and put into an algorithm or not.
Yeah, I mean, fundamentally, it's what makes AI in this space so much more complicated, is that there's not necessarily core agreement as to what the single objective function is of a government agency, because you're talking about something as diffuse as social welfare as opposed to just revenue and profits, and so that's what makes a lot of these decisions much harder.
So if we go back to pre-industrial times and future forecast our history, then what is the next point in our future? Before the production systems came, before the Henry Ford production lines came in, it was a very different side. If we go back there, stand there and future forecast and see how technology has progressed, then what will be the next point? Where does AI fall?
I think in a sense, actually, a lot of the panel's discussion has been about trying to get an understanding of where that frontier is as a descriptive matter, and we could kind of try to extrapolate from that. But I'm not sure if any of the other co-panelists have a good forecast here as to.
I'm not sharing it.
Last question. Yes.
It struck me that you just said that the complicated thing about AI in government is that the optimization function is more complicated. And I wonder if, to what extent that is true. Like, it seems to me that a lot of the conversations that are going on here at Stanford and beyond about optimization strategies in AI are precisely around the question of like, how to, sort of like solve trade-offs from efficiency and equality to like all sorts of other like questions that are generating the conversations that we're having now about the impact of the use on society. And so I wonder, like thinking about a regulatory framework, what do you expect the sort of like the regulatory framework for the government use to be substantively or sort of like structurally different from a regulatory framework for industry?
I think so. I think it's a really profound question. I don't know if others want to chime in here. I mean, I'll say one quick thing, which is just in the adjudication setting, there is the very sort of rule that tells you whether you're eligible for disability benefits is completely humanly created. It depends on who sits in the appeals court, right? And they're they may be wrong. Right? And so it's a kind of complex system where you don't have like an objective referent by which you can know whether or not this decision is accurate, right? And so I think that makes it just a much more thorny measurement problem. Sharon?
I was just going to say, as I was saying at the outset of my little talk, was the consequences when you're dealing with government are vastly different than when you're dealing with commercial uses. So the government can put you in jail. The government has entitlement to benefits. We have notions in our law of due process, meaningful notice and a right to be heard, that apply to the government that don't apply in the context. I mean, we would like to get due process, I'm sure, from private companies in many contexts, but it's a very different framework, and what's at stake is very different. Don't get me wrong, I think there's also a strong advocate for consumer privacy legislation. I hope we will get that here in this country, and AI is one component of that, and we do need to have safeguards for what companies can do with our data, how they handle it, how long can they retain it, what kind of secondary uses or sharing. There's a whole lot of issues, but I think they're different issues than government, and government just raises a whole nother level of concerns that for me in many ways are more scary.
That's that there are clear analogs, right? So if you're thinking, we've talked a bunch about fairness, and that has been a really challenging literature to try to understand, right? The ideal is we write down a formal definition of fairness, we choose that, we treat everything as a constrained optimization problem, and then we've met that one definition of fairness. Well, what we've seen over the past few years has been the explosion of 27 different definitions of fairness. We have the impossibility theorems. They're mutually incompatible, and so then you're ultimately forced to make these kinds of normative decisions, even in the private sector context, if you're trying to ensure that whatever private AI tool you're adopting, doesn't have a disparate impact, for instance. Okay, with that, I think we're out of time. So let me just a round of applause.